What are the consequences for cheating in a Florida divorce case? 0. That's the end of this video. Please make sure to subscribe. Just kidding. I'm Sarah. This is my channel. Welcome to it. I hope that you subscribe and that you are enjoying the content that I'm putting out. Today, I wanted to talk about, in Florida, what are the consequences for cheating in a divorce case. So I've been practicing family law in Florida for quite some time now. I do only practice in the state of Florida. I am licensed in other states, but all of my videos here are exclusively talking about Florida law. Other states have similar laws that may apply, but for now, this video is just Florida law. In Florida, cheating doesn't have a lot of consequence or effect on a divorce case. Cheating does not affect equitable distribution in a Florida divorce unless there is dissipation. Equitable distribution is the division of your marital assets and liabilities. Dissipation is the intentional waste, depletion, or misconduct of marital money. And remember, it has to be intentional. But intentional dissipation can be spending money on your affair. Let's say, for example, you are spending money because you are flying to California and you're staying with your new boyfriend in the Ritz-Carlton in California, and you're putting the Ritz hotel on your credit card, and you're going out and buying clothes for your boyfriend, and you're going to dinner, you're going to expensive shows, and you're putting it all on your credit card. You then come home and you pay your credit card off with your joint checking account with you and your spouse. That money that you have spent on your affair partner can be considered dissipation. If there is dissipation in Florida, the money that was spent is brought back into the proverbial pot, the marital estate pot, and it is assigned to the spouse who spent the money. So the money, pretend that the money is still back in the pot. Now, dissipation has to be proven. It's not a simple thing to prove, so you have to be able to actually show that the money was spent on an affair. Now, let's say you're paying for your side piece with your own money. Now, let's say your own money is a bank account that's in your name alone, but that you have been depositing your earnings from work throughout the marriage into that account. And then you pay your credit card that you were, have all the Ritz charges on using your own money. That is still dissipation, because in Florida, it doesn't matter how an asset was titled. So it doesn't matter that the bank account is in your name alone. Unless you have a prenup, the law in the state of Florida says the titling of the asset doesn't matter. If it was earned or acquired during the marriage, it's a marital asset in Florida. So if you're spending your own money on your side piece, it can still be dissipation. In Florida, cheating does not affect timesharing. And this might be a really tough pill to swallow, because somebody who cheats is a partner. They're not a good spouse, but it doesn't necessarily mean that they're a bad parent. In Florida, the factors that the court can consider in awarding a timesharing schedule that's not an equal schedule, none of those factors have to do with cheating. There is a factor about the morality of the parties, so maybe you can use the cheating under that factor, but I've never seen it used, and I think you probably get an objection about the relevance of it, because really, cheating has no effect on timesharing in Florida. Does cheating affect alimony in Florida? Maybe. The statute in Florida, the new alimony statute, says this about cheating. It says the court may consider the adultery of either spouse and the resulting economic impact in determining an amount of alimony, if any, to be awarded. So what does that mean? I've never seen this used, this provision in the statute used. Does it mean that if you were the cheater and you are also looking to receive alimony, your cheating nullifies your potential alimony award? What happens if you're the payor and you also cheated? Does that mean you pay more than statutory alimony? It's really an unclear provision in the statute. It's a newer statute from 2023. There's no good case law on it yet, but generally, other than that one caveated sentence, cheating doesn't really have an effect on alimony in Florida either, unless we can figure out what that one caveat means and some good case law on it. But for now, we've got really nothing on it. Now, I do have some good news for you today. You can make cheating count in a prenup. You can have a cheating clause in a prenup, and your prenup can specify that if there is cheating, XYZ happens. You get more in equitable distribution. Instead of it being an equal division of the marital assets and liabilities, you get 60%, 70%. You can include in your prenup a cheating clause. If there's cheating, you get more alimony. Or if you're the payor and the other side cheats, they get no alimony. You can make the law in a prenup, and that's the beauty of prenups, but not so fast. You cannot include a provision in your prenup that says if you cheat, you get 0 time sharing with your kids. Kids issues cannot be included in the prenup. That has to be decided at the time of the divorce and what's in the best interest of the children. So unfortunately, cheating and time sharing, you can involve the two. So I hope this video didn't piss you off. I hope that you didn't absolutely hate it, but please feel free to put all of your thoughts and comments in the comment section. I'll read them, even the mean ones. If you were cheated on, I'm really sorry. And if you were the cheater, you're kind of lucky it's not gonna affect your divorce case. Make sure you give this video a thumbs up and subscribe to my channel.